Calhoun. And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, with the judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts to make this a third degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by a felon, July 8th of 2019. And are all three of those prior convictions true?
Mm-hmm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you?
Yes.
Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal in cause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance, those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence.
What I gave them wasn't all of it. Apparently ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay,
I printed one for me, several things for myself.
well, I think it's something.
Okay. All right. Here you go. You can go back with the bailiff.
No. Yeah. 9-6, whatever. 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trahan is currently competent to stand trial. Any other evidence with regard to competency
No, Your Honor.
from the state?
No.
Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, Your Honor.
And are we going on count 1 only? On the assault on a peace officer?
Yes, sir. We may need to go on both on the staging.
Okay. Hold on a second. Right. Sorry. You'll be waiving or giving up any right to appeal.
Right.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one in each case.
Objection.
It's admitted in each case. Get caught up here. All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And cause number 25, BCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in cause number 25, DCCR 1916. All right, you can go back with the bailiff. So, Mr. LeBlanc, you've done so. Chambers County rejected the charge.
January 28th, Your Honor.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail and this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while, and working a forklift. He does do classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online, that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January the 20th, he hired me and then surrendered to the court, Your Honor. His mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment. And we would ask that the court follow that alternative.
Mr. LeBlanc, you've done so well. Better than most. You've done. So the fact that you've done all your community service, Mr. LeBlanc, you've done so well. Paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal, and so you're not supposed to use it. If it's going to show positive in a drug screen, you can't use it. You understand? There's no way for us to know if it's legal. All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true. Find sufficient sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way over on, you're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. And so you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. Be required to enroll. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes,
If there's any issues that they find. So this was an agreement, so you do have some rights to appeal. You can talk to Mr. Lane about that, and I need you